If you think you are safe because you watched a video claiming that the Supreme Court issued a 9-0 ruling that flipped gun laws in 19 states, I need you to stop and listen very carefully. Because the specific claim in that title, the 19 states, the panic mode, the gun laws got flipped, does not describe any real Supreme Court decision. A Florida board-certified criminal trial attorney named W.F. Casey Ebsary Jr. specifically warned about these viral clips in March 2026, writing publicly that videos making sweeping claims about unanimous Supreme Court gun rulings are, in his words, fake or at best dangerously misleading, and that acting on them can get you arrested, charged, and convicted. He is right, and I will tell you why in a moment. But here is the important thing. There is a real 9-0 Supreme Court decision about gun rights that came down on June 18, 2026. It is called United States versus Himani. It is a significant constitutional ruling. It does affect millions of Americans. And most gun owners I have spoken to either have never heard of it or have heard the wrong version of it from a viral video that exaggerated what the decision says. So today I am going to do two things. First, I am going to be completely straight with you about what the viral claim gets wrong and why it matters that you know that. Second, I am going to explain what Himani actually says in plain language so you understand your real rights under the real decision. Subscribe now, because this is exactly what this channel exists to do. Not to get you hyped up with a headline that is not accurate. To give you the actual law so you can make actual decisions. Let me start with the viral claim. The title says 19 states are in panic mode after a 9-0 ruling that flipped gun laws. Here is the problem with every part of that claim. There is no Supreme Court ruling that has targeted 19 specific states. The number 19 does not correspond to any identifiable group of states affected by any recent Supreme Court gun decision. The word panic is a media invention, not a legal description. And the phrase gun laws just got flipped does not accurately describe how Supreme Court decisions work. The court does not flip state gun laws by issuing a single ruling. It decides specific legal questions about specific statutes or constitutional provisions, and those decisions ripple through lower courts over time. When you see a video making claims that specific, that dramatic, and that sweeping about a court decision, the right reaction is not excitement. It is skepticism. Because the law does not work the way viral videos describe it. Now here is the actual 9-0 decision. United States versus Himani, case number 24-1234, decided June 18, 2026. Justice Neil Gorsuch wrote the majority opinion. Every justice agreed on the outcome, meaning the vote was 9-0 on the judgment. There were 5 separate concurring opinions from different justices expressing different reasoning, which means the unanimity on the outcome was broader than the unanimity on the rationale. But on the bottom line, every single justice agreed that the prosecution of Ali Himani violated the Second Amendment. Let me tell you who Ali Himani is, because the facts of this case matter enormously for understanding what the ruling means and what it does not mean. Himani is a dual citizen of the United States and Pakistan who was born in Texas and has spent most of his life living in the Dallas area. The FBI suspected Himani and his family members of terrorism-related activities. Agents executed a search warrant on the family home. During that search, Himani was cooperative. He surrendered a gun he kept in the house. He pointed agents to some marijuana on the property, and he consented to an interview in which he told law enforcement that he used marijuana about every other day. More than 6 months after the search, and relying solely on Himani's admitted marijuana use, the government charged him under 18 U.S.C. Section 922 G.3. That is the federal law that makes it a crime for any person who is an unlawful user of or addicted to any controlled substance to possess a firearm. The penalty is up to 15 years in federal prison. The government never claimed Himani was dangerous, never claimed he was intoxicated while armed, never claimed he was a genuine addict, just that he used marijuana a few times a week and had a gun at home. If you are finding this important, subscribe right now, because what I am about to explain about why the court ruled the way it did is the most important part, and it determines exactly who this ruling protects and who it does not. The Supreme Court applied the Bruin historical tradition framework. That means the court asked whether there is a historical analog, a law from the founding era or the Reconstruction era, that is relevantly similar to the modern prohibition on the marijuana user in possession of a firearm. The government's best historical analog was a category of laws regulating habitual drunkards. Historical habitual drunkard laws allowed courts to institutionalize people who drank so excessively that they could not manage their own affairs. The government argued those laws are relevantly similar to the modern drug user gun ban. Justice Gorsuch's majority opinion systematically rejected that analogy for three independent reasons that are worth understanding because they tell you exactly where the law now stands. First, on who was targeted. Historical habitual drunkard laws did not target people who simply drank regularly or even frequently. They targeted people who drank so excessively that they were practically incapacitated, unable to conduct their own affairs. Section 922, G.3, as the government applied it, targets anyone who uses any controlled substance with any regularity, regardless of how their use affects their functioning. The scope is fundamentally different. Second, on why the laws existed. Historical drunkard laws targeted people because their incapacity made them genuinely dangerous to themselves and others when armed. The government in Himani specifically made no claim that Himani's marijuana use ever made him dangerous. Third, on how the laws operated. Historical habitual drunkard laws required individualized legal proceedings. Courts made specific findings about specific individuals before restricting their liberties. Section 922, G.3, as applied here, is entirely automatic. You use any controlled substance with any regularity, and you are instantly a prohibited person, with no hearing, no finding, no individualized assessment of any kind. Hey, 73% of people watching right now are not subscribed. This case is the most important gun rights decision of 2026 for millions of Americans who use marijuana and own firearms. Subscribe right now so you get everything you need to protect yourself. Gorsuch summarized the problem with a sentence that has already become famous in gun law circles. He wrote that the court can see no reason to think that the many millions of Americans who regularly use marijuana recreationally are generally dangerous. He also noted that marijuana use has become so widespread, widely accepted, and now legally permitted in a large majority of states that treating marijuana users as categorically dangerous is simply unsupported by any genuine historical tradition. The historical analog the government offered failed on every metric. The prosecution was unconstitutional. 9-0. Now let me tell you what this ruling does not do, because this is where the viral versions get dangerous. Himani is what lawyers call an as-applied challenge. Himani did not ask the court to strike down Section 922, G.3, entirely. He asked the court to hold that the statute cannot be applied to someone in his specific situation. Someone who occasionally uses marijuana is not dangerous, is not intoxicated while armed, and is not a genuine addict. The court agreed with that narrow argument. The statute remains on the books. The DOJ can still prosecute people under it. The question is what additional showing the government must now make to support a constitutional prosecution. This is absolutely critical for you to understand. The Himani ruling does not mean that marijuana users have a free right to possess firearms. It means that prosecutors cannot use marijuana use alone without any showing of actual dangerousness to automatically disqualify someone under Section 922, G.3. There will be future cases working out exactly what more the government must show. Those cases have not been decided yet. The line between what is and is not constitutionally permissible under this statute after Himani is genuinely unsettled and will be worked out in courts over the coming years. What does this mean in practice right now? If you are a marijuana user who has been charged or convicted under Section 922, G.3, and the government presented no evidence beyond your marijuana use, Himani may be extremely helpful to your case. Contact a criminal defense attorney immediately. If you are a marijuana user who also owns firearms and the government has never charged you with anything, Himani has improved your constitutional position, but it has not made you legally immune. Federal law still prohibits unlawful drug users from possessing firearms. The ATF background check form, Form 4473, Question 21E, still asks whether you are an unlawful user of or addicted to any controlled substance. Answering that question falsely is a separate federal crime. Himani does not change the Form 4473. If you use marijuana legally under state law but live in one of the states where recreational or medical marijuana is legal, you are in a genuinely complex legal situation that Himani has not fully resolved. Federal law still treats marijuana as a Schedule I controlled substance. Himani narrows when the government can prosecute you for possessing a firearm, but it does not eliminate the federal prohibition entirely. This is a rapidly evolving area of law, and you need current, state-specific legal advice. Let me also put Himani in the context of 2026's broader pattern of Second Amendment decisions. The same Supreme Court term produced the 6-3 ruling in Wolford versus Lopez that struck down the vampire rule in Hawaii and 4 other states. The same term is about to produce a ruling on the Trump administration's birthright citizenship order, and the court is watching multiple assault weapons ban cases percolating through the circuits. Himani fits into a clear pattern. The court is applying the Bruin historical tradition test consistently. Laws that lack adequate historical support are being struck down or narrowed. Prosecutions that sweep in people who pose no demonstrated historical analog to genuinely dangerous individuals are failing. Himani's principle of requiring individualized evidence of dangerousness before disarmament echoes the language in Rahimi's 8-1 ruling and is being written into the fabric of Second Amendment law. Now let me address the danger of the viral versions of this story directly, because this is important. When a video tells you that a Supreme Court ruling has flipped gun laws in 19 states, and you believe it, and you start acting on that belief, one of several bad things can happen. You may carry in a location where you are not permitted to carry and be arrested. You may possess a firearm while in a legally disqualifying status and be prosecuted for a federal felony. You may make decisions about what you can legally do that are based on a ruling that does not say what the video claims. And you may use that video as a defense in court, where a judge will tell you very clearly that neither viral videos nor internet interpretations of Supreme Court decisions constitute a legal defense to criminal charges. Ignorance of the actual law is not a defense, and relying on misinformation is not a shield. The Florida attorney who specifically debunked these viral gun ruling videos made a point that I want to repeat here. No court will accept a viral video as authority. No prosecutor will back down because you cite a YouTube title. And if you get arrested based on behavior you thought was protected by a sweeping ruling that does not actually exist, you will pay those consequences with your freedom, your record, and your gun rights for life. This is not about being afraid of your rights. This is about understanding your actual rights accurately so you can exercise them safely and legally. Here is your complete action plan based on what Himani actually says. If you use marijuana and own firearms, do not assume Himani makes you fully protected. Consult with a firearms attorney in your state about your specific situation. If you have been charged under 922G3 for marijuana use alone, contact a criminal defense attorney immediately. Himani is a powerful argument in your favor. If you have previously been convicted under 922G3 for marijuana use alone without any showing of danger, consult an attorney about whether Himani creates grounds for a post-conviction challenge. If you are purchasing a new firearm and you use marijuana, understand that Form 4473 still asks about drug use, and answering falsely is still a separate federal crime. And for everyone, when you see a viral video making dramatic claims about a Supreme Court ruling that has changed gun laws in a specific number of states, be skeptical. Look up the actual decision. Read the actual holding. Get actual legal advice. Your rights are real. Your responsibility to understand them accurately is also real. Subscribe right now because this channel gives you the actual decisions, the actual holdings, the actual language from the opinions, and the actual practical implications, not the version engineered for maximum clicks. I will be covering the remaining decisions from the current Supreme Court term as they come down. And please remember, this is educational content only, not legal advice. For your specific situation, consult a qualified firearms attorney. The real law is important. Know it accurately.